Welcome, everyone, and thank you for joining us for NAVA Talks AI. Last week, we had a very comprehensive session by Siobhan Wright, practicing artist and lawyer at Terry Jenke and Company. Siobhan shared some information around how AI is currently interacting with traditional knowledge and ICIP, and some good practice protocols for ensuring appropriate AI use that upholds ICIP rights and principles of Indigenous sovereignty. If you missed out on the NAVA Talks AI and ICIP webinar, you can visit the NAVA events page on our website to view the recording, and we'll paste the link into the chat as well. Today's session is the second of 3 online sessions where industry experts will discuss the legal and ethical tensions at the intersection of artificial intelligence, aka AI, and arts practice. Specifically, we'll be exploring the potentials and risks of generative AI in areas like Indigenous cultural and intellectual property, copyright and intellectual property, as well as the impact on artists' work and livelihoods. This series is intended as one of many starting points for discussing good practice approaches to protect artists' rights and ensure they are fairly compensated in the use of AI. Before I go on any further, NAVA acknowledges and pay respects to the rightful custodians of the many First Nations lands upon which this online event will be streamed and received. We recognize the custodians of country throughout all lands, waters, and territories, and pay respects to First Nations communities, ancestors, and elders. Sovereignty was never ceded. My name is Emma, and I am the New South Wales Professional Development Coordinator at NAVA. I am here on Darug and Darrell country, and I will be the NAVA MC for today's session. So just some quick housekeeping. This session will be Auslan interpreted by our wonderful interpreters, Imran Webb and Susanna Lee. If you are needing their support, you can click on the 3 dots on the video to pin them to your screen. Once they are pinned, they will remain visible on your screen throughout the session. We are also live captioning today with our captioner, Helen. Please also note that this session will be recorded and will be made available on the NAVA events page on our website. And you will be sent an email to notify you when the recording is available. So we highly encourage you to participate in the discussion today by submitting a question using the Q&A feature. We'll then be asking a few of those questions at the end of the session and thank those who have submitted a question already upon registering. We'll also send around a survey link at the end of the session so that we can hear about your experiences in this space and any feedback that you might have for us. So talking about AI feels like a really urgent topic, especially because the technology is continually unfurling before our very eyes, and its use is becoming more prolific in the art sector and also beyond. At NAVA, we've been conducting work to try and stay informed in this space to ensure that artists and creators' rights remain at the forefront of the conversation. I'd now like to welcome Georgie Cirillo, who is NAVA's Deputy Director, to talk a little bit more about NAVA's work and AI.
Thanks, Emma. And thank you everyone so much for joining us here today. It's so good to see you all interested in this topic. And of course, thank you to the wonderful Catherine Giles, who'll be introduced to you in a second. I'm here on Ngunnawal and Ngambri country, where I work and live, on country where sovereignty was never ceded. I wanted to briefly provide a little bit of context around NAVA's advocacy work in relation to AI, in particular generative AI. It's all moving very quickly, as Emma mentioned, and of course feeds into today's discussion. Firstly, just a little bit about NAVA. So we are an independent membership organisation, bringing together the voices of the visual arts, craft and design sectors. Our work revolves around improving the fundamental conditions of work and practice, which we do primarily through advocacy, education, and promotion of the code of practice. So currently our engagement in the work around AI is focused on the promotion of responsible AI adoption, and also creating awareness around existing and potential harmful outcomes of its use, such as copyright infringement by generative AI platforms, the continued unlawful reproduction of Aboriginal and Torres Strait Islander art, and the derogatory treatment of artwork as a few examples. Certainly not all negative though. We know that artists are already doing brilliant work with AI and that this tech will create opportunities for artists, arts workers and organisations. But first and foremost, we are concerned with protecting creators. We're still learning as AI evolves and legislative systems catch up, which is why sessions like this, conversations with peers, colleagues, and sharing of knowledge and experiences is all very critical. So if you're engaging in AI in any way, we would love to hear from you. There'll be a survey circulated after this session, and you're always welcome to contact us directly via email at nava@visualarts.net.au, or pop that in the chat as well. And also, if you have any questions we can't get to today, or in the other sessions, then you're welcome to send them through to our email as well. So thank you so much, and I'll hand you back now to Emma to introduce our presenter.
Thanks so much, Georgie. So today's session will build on the last by diving further into this crossover of AI and copyright. As Georgie mentioned, today's guest is Catherine Giles. Catherine is a lawyer and head of legal and operations at Arts Law. She has worked in private practice and in-house, including as a lawyer in the legal team at the Australian Broadcasting Corporation. She draws on this experience to provide advice to artists and arts organizations on governance, intellectual property law, copyright law and policy, entertainment law with a specific focus on music and publishing, confidentiality, commercial transactions, disputes, privacy, and media law. Thanks so much, Catherine, for joining us today. As you know, generative AI is becoming an ever more common tool for artists to critically and creatively explore within their practice. However, with the proliferation of AI generative platforms that mine images of the internet without artists' consent, this raises several copyright concerns. And we explored some of these implications of the data scraping on Indigenous cultural and intellectual property last week. So today, Catherine, we're hoping to hear from you more on AI and copyright infringement more broadly, and some ways forward from Arts Law's perspective for safeguarding the copyright and intellectual property rights of artists. So I'll hand it over to you now.
Thank you, Emma. I'm just going to share my screen so that everyone can see the slides. So hello, I'm one of the lawyers at the Arts Law Centre. And just a little bit of background. First of all, Emma's already given you the background to me as a lawyer, but just a little bit of background about Arts Law and our Artists in the Black service as well. So some of you may have used the Arts Law service before. I'm just trying to, oh, here we go. We're a community legal centre. We're a national community legal centre, and we provide legal advice to artists and arts organisations all around the country. We have a telephone legal advice service, which many of you may have used before. We have a website, and on that website, we have available lots of information sheets on a variety of topics, including AI and copyright, and sample agreements as well. We also provide legal document reviews for clients, and we run workshops and seminars, and we do a lot of advocacy as well. And the area of AI and copyright is a space in which we've undertaken a great deal of advocacy, along with organisations like NAVA. Other areas where we undertake a lot of advocacy and sort of policy law reform work is in the Indigenous cultural and intellectual property space, and pushing for greater protection for ICIP, and also the prevention of fake art reaching our markets as well, and really focusing on the impact that has on Aboriginal and Torres Strait Islander artists around the country. Our Artists in the Black service is sort of part of arts law and is really specifically focused on providing legal advice and empowering Aboriginal and Torres Strait Islander artists through the law. And I'm not going to focus specifically on ICIP and AI today, because I know that NAVA's session, which was really wonderful, has already focused on that. But it is a really big issue, and it's really great that NAVA has started this series by focusing on the impact of AI on ICIP in Australia. This map is great here. It sort of shows all the places that we travelled between 2018 and 2022. We need a 2023 map. That's on the list of things to do, but it is really a huge part of the work that we do at Arts Law and through the Artists in the Black service, is really trying to work as much as we can face-to-face with artists and arts organisations, particularly Aboriginal and Torres Strait Islander artists and art centres around the country. So moving on to the issues that we're going to talk about today. I know that last week's session focused a little bit on copyright and covering off on all the different issues that arise from copyright, how it is created, what it is, because you can't really talk about Indigenous cultural and intellectual property and the impact of AI without first looking at copyright. But we're going to delve back into it today, partly just to give everyone a little bit more insight into that mix between copyright and how it is interacting with AI and the impact of AI, and also for those who didn't attend last week's session as well. So I'm going to focus on firstly on copyright, what it is, who owns it, what rights does the copyright owner get, and also moral rights as well, because that's another important right that creators have, and AI has had an impact on that as well. And then I'm going to look at what AI is. Many of you will already know what AI is, but for those who don't, it will sort of give you a little bit of insight, and also just really focusing on the impact of AI in the art space. I'm then going to briefly look at some of the legal challenges to AI, most of which are happening in the US at the moment, just to also give you some insight into things that are happening overseas, and sort of raise the question of whether we're about to see sort of similar cases arising also in the Australian legal space. And then also talk about some of the regulatory developments in this space as well, which is very much a watching brief at this point, particularly in Australia, but there is a lot happening, and a lot of discussions taking place. And then ending off the session with some next steps. What are some of the things that all of us can do? What are some of the steps that artists can take? And I know that that's something that artists come to Arts Law to ask about, and also to NAVA. And for many of you, when you registered, that was a question that came up as well. So why does copyright matter? It matters because it's a group of rights that creators are granted under our Copyright Act when they create a work. So it gives creators some economic rights to create ongoing income, to license their work, to sell it, assign it to others, to distribute it, to collaborate with others, and also to essentially create their own income, their own business practice from their work. Both Arts Law and NAVA are really focused on, fair pay for artists, to ensure that artists are compensated for the work that they do, that what they do is recognised as work, not just as a hobby that people undertake where they should be doing things for free. But copyright's also interesting because it really is about balancing the rights of the creator or the copyright owner, who may not always be the person who's created the work, and the public's right to use and enjoy art, literature, music, and all of those things that are copyright works. So there's always that sort of tension and sort of like trying to seek that balance within copyright law. So what does copyright protect? Well, I like to think about the Copyright Act, which we have in Australia, which is a Commonwealth piece of legislation, as sort of having little boxes within it. And to get copyright protection, your work that you create needs to fit within one of these boxes. So we have things that we call works, and those are literary, artistic, musical, and dramatic works. And then we have things that we call subject matter other than works, which is a bit of a mouthful. And some of those include broadcasts and films and sound recordings. What we're going to focus on today is artistic works, but AI is having a really big impact on some of these other copyright works as well. For writers, it's also a really big issue in terms of their works being scraped and included in ChatGPT and other AI tools. For filmmakers, for performers, for musicians, AI is also a huge issue as well. But today we're really going to focus on artistic works. The other question that comes up with copyright is who owns the copyright in a work when it's created? So generally, the copyright owner is going to be the person who creates the work, particularly if it's what we call a work. If it's a subject matter other than work, like a film, a sound recording, or a broadcast, the rules are a little bit different, and we're looking at who the maker is. But because we're going to talk about artistic works today, we're going to focus on the creator. So usually that's the artist, the photographer, the sculptor, the person who has created the artistic work. So generally they will be the copyright owner. There are some exceptions to that rule in the Act, and I'm not going to go into those into detail today because they don't really have an impact on the sort of AI space. But if you're an employee, that will change that general rule. If you've entered into a contract, there might be a clause in the contract where you assign the copyright. Commissioned works can also be a little bit different as well. And we have this thing called Crown copyright. I'm also not going to go into that today, but just so you know, sometimes with law, there's a rule and then there's always a but, an exception to that. So with copyright ownership, we just need to remember that sometimes there are exceptions. The other thing about copyright ownership and who the copyright owner will be is that it generally needs to be created by a human author or have some sort of human effort that's part of it. So I've included this cute little photo here because many of you will remember in the news the sort of controversy and questions raised when animals start taking photographs and whether the animal is able to own the copyright in the photograph. And these same questions also come up in the AI space when we think about whether AI itself, like the tool or the platform, is able to own copyright in a work. In Australia, we have quite a bit of case law in this space, and the Act is also pretty clear that it needs to be a qualified person, and there needs to be some sort of human effort or contribution that goes into the making of the work. So as I said, this question has come up in the AI space. Who is the creator, and can you use an AI tool in the same way that you would use a paintbrush or a camera or any other sort of artistic tool that you use to create works? And it isn't something that we sort of have a decision on yet, particularly in the Australian space. But I think this particular example is really interesting because last year when this situation arose with Boris Endelson, sorry, I probably mispronounced that, who won a photography award, he had used an AI tool to create the photographs. But when you read about the process that he undertook to create those photographs. It wasn't like he'd used an AI platform and just said, black and white photograph of woman. There were so many different prompts that he'd used during the process of creating these photographs that it's hard not to think that there isn't some kind of human effort and skill that's gone into the creation of the artistic work. And it may be that in situations like this, we can think of AI as being like a paintbrush or being like another digital tool that we use on a computer when we're creating digital artwork. But it's a little bit undecided, and it really is going to be something that I think is very much going to be considered on a case-by-case basis. And it's really going to depend on what the artist has done, how many steps they've undertaken themselves, how they've used the AI tool. And it's a little bit of an uncontested space, and I'm really interested as a lawyer to see how it will play out. But this article and this particular situation, when it arose, it really made me think differently about how AI tools are used by artists. And I will come back to it, but NAVA and Arts Law did a survey last year of artists and asked some questions about how AI has impacted the work that they're doing and whether they're using AI. And a lot of artists responded and said, yes, they are using it, particularly doing like in the space where they're coming up with ideas, playing around with different images. And so for some creators, AI is a tool that they're using in the same way as they use a paintbrush. So coming back to copyright, we've got the copyright work. We know who the copyright owner is, but what does the copyright owner get? So under our Copyright Act, the copyright owner gets a number of different exclusive rights, and they will depend on which type of work it is. But because we're focusing on artistic works, we're going to look at the exclusive rights that are highlighted yellow here. So the owner of the artistic work gets the exclusive right to reproduce the work, to publish the work, and to communicate the work. And communication really means to make it available online or electronically transmit. So those are the exclusive rights of the copyright owner for the duration of copyright. So the duration of copyright is not forever, it's for the lifetime of the creator plus 70 years after their death. So it is quite a long period of time, and during that time, those rights are exclusive to the copyright owner. There are some exceptions to that, and we will come to that in a minute. So we've got the work, we've got the copyright owner, we know what rights the copyright owner gets, but how is copyright actually infringed? So copyright infringement is also really interesting and can be a little bit of a grey space, because it's really easy when the whole of a copyright work has been infringed. So the whole of a copyright work has been copied and reproduced or communicated or published without the copyright owner's permission. But infringement can also take place when a substantial part of the work is taken and reproduced, communicated, or published without the copyright owner's permission, subject to some exceptions that we're going to talk about. But what a substantial part is can be a little bit difficult to quantify sometimes. And that's because it's a qualitative test, not a quantitative test. So it's taking the essence of the work. Some people will say if you take something that's recognizable, then that is a substantial part. So we're using the Mona Lisa here as an example. You have the work, you have the smile, you have the eyes, you have the background, each of those three portions. And you could raise the question about each of those as to whether they are a substantial part. I mean, for many of us, we would definitely say that the mouth and the eyes are a substantial part. They're very recognizable. But would we also say that that little sort of corner that's more of a blurred sort of landscape, is that also a substantial part? It could possibly be considered a substantial part of the work. I shall also say that this work is no longer in copyright. The duration has expired, but I'm just using it as an example there. So when we think about AI, this is really interesting because if an artwork is scraped, and then used in an AI generative tool platform has a substantial part of the artist's original work being reproduced and copied as part of that scraping and training process that's used within the AI platform. And I'll come back to that in a minute. So the other thing that's interesting about copyright law is sometimes you don't need to get permission from the creator to exercise one of their exclusive rights. So there are a number of different exceptions in the Copyright Act. Some of them are quite complex. The area of statutory licenses and education licenses is a really big area of copyright law that some people specifically specialize in. And you can also get Creative Commons licenses, so the works may be able to be used under Creative Commons license. In essence, that's almost a form of permission. And then there are some other little exceptions like incidental use in films, public sculptures, if they're in a public place, you can take photographs of them, etc. And then we have fair dealing exceptions. So they're very specific exceptions in our Copyright Act that allow you to use copyright works without seeking permission from the copyright owner. Some of those exceptions include fair dealing for the purpose of research or study, reporting the news, which the media rely on quite often, criticism or review, which someone who's doing a review piece or criticism piece of an artwork, for example, might rely on, and parody or satire, which is something that a lot of people in the media, entertainment and art space do rely on if they're wanting to make a parody or satire artwork that might reproduce the work of someone else. What we don't have in Australia is very broad fair use exceptions, which they have in the US. And we don't have data and text mining exceptions, which they have in other jurisdictions, including the UK and the EU. So that makes us a little bit different in this AI space as well, because there are some people who say that, the fair use, the broad fair use exception could be relied on by AI tools or platforms in the US if they are reproducing and communicating works for a training purpose. So just to remember to keep that in mind when you're thinking about Australia, we're a little bit of a different jurisdiction. And there is sort of discussion in the copyright space about how a copyright infringement case would play out here in Australia, because an AI tool or platform company wouldn't be able to rely on our fair dealing exceptions if they were found to have copied, communicated or reproduced artistic works. The other thing that the creator gets under our Copyright Act is moral rights. So they are personal rights held by the creator, recognising the connection the creator has between themselves and the work they've created. There are 3 moral rights that creators get under the Act: the right of attribution, the right against false attribution, and the right of integrity in the work. So Georgie referred in her introduction to derogatory treatment of works. And if a work was treated in a derogatory manner, was changed, altered, or something else which the artist felt had a negative impact on them as a creator, that could be a moral rights infringement and an infringement of the moral right of integrity. Again, when works are scraped and used in these AI tools or platforms, as far as we know at the moment, and we haven't seen it, there isn't any credit or attribution given to the original artist. And so we can see here that that moral right of attribution is definitely an issue here with AI tools. So now that we've got the copyright basics sort of down pat, we've talked about works, we've talked about who the copyright owner will be, the rights that they get, some of the exceptions, and also moral rights. Let's now think about how those laws that we currently have in place that do protect creators and give them rights in the works that they create, how do they interact with AI tools? So many of you will have heard lots of different descriptions of different types of AI tools. You know, we were joking before, just when we started off the session, about Zoom and, you know, how there's AI in the Zoom and it's everywhere. There's lots of different things that we're using, whether it's speech recognition technology, virtual assistants, all of those kind of things that are using some form of AI technology. If you have a self-driving car, then that will also use some AI technology as well. But when we're thinking about the art world and copyright, we're really thinking about those generative tools that are using different types of AI technology to learn and create images. Text tools are also very similar in terms of the way that they're scraping text from the internet and then using that as part of the AI tool. So some of the generative AI tools that are operating in the art space and also in the text space are ChatGPT, Stable Diffusion, Midjourney, Wombo and Lensa. I mean, many of you have probably either used them or heard of them, but they're the kind of tools that we know have sort of scraped various images and text from the internet and used it as part of the learning process for the AI tool, and then creating a generative tool as a process after that. So even the companies and people who work for the AI companies recognize that it would be impossible to have the tools that they have without copyright material that they've used to train the tool. So there is a little bit of a dispute over whether that training process actually involves reproduction and communication of copyright works. And because of the lack of transparency about how the tools work and the lack of transparency from many of the tech companies, it's kind of hard for us to know. And there is a bit of a dispute over whether there is communication and reproduction involved. But it appears, particularly when we start looking at some of the cases in the US and some of the evidence that's been put on in those cases, that there is copying, so reproduction and communication taking place. And what we're thinking about when we look at these AI generative tools is, what are the inputs that are being used as part of the training process? And then what are the outputs? And when we go back and think about that issue of infringement and whether a substantial part of the work has been used, we're looking at whether a substantial part has been communicated and reproduced during the input process and then during the output process. So this is just an example here, an Australian example of an artist, Kim Lutweiler, who was able to work out, using a site that many of you may also heard of called haveibeentrained.com. She was able to use that to work out that her work had been used in a data set of images and text captions taken from the internet and then used in different types of platforms to train various AI systems. And when we're thinking about the copyright and moral rights issues that come up during this input and output process, we're looking at reproduction and communication of the works during the input process, copies being kept as part of the training data or other inputs into the platforms. As I just referred to earlier, no attribution, so no credit being provided to the original creator of the work. Any adaptations or changes that are made to the original works during that input process, again, a moral rights, potential moral rights infringement, and that there is no applicable fair dealing exception in Australia that would cover that type of use. And then when we look at the outputs, so the works that are generated by these AI tools, we're looking again at the exploitation of works and creating outputs that would reproduce and communicate a substantial part of an artistic work, a copyright work. And even if that might be sort of unintentional or subconscious copying, it could still be considered an infringement. Again, the infringement of moral rights, both failure to provide a credit and an infringement of integrity. And then it also raises the question of the output and whether there is a human creator as well, which is a little bit unclear. So if we think about who the potential infringers might be in this output process, it could be both the company that has created the generative tool and also those who are using it, if there are underlying works that are being reproduced and communicated without the copyright owner's permission. So as a result of all of that, there have been some legal challenges to AI systems. Most of these challenges have taken place in the US. And this tweet here is actually one that was reproduced in part of the evidence put forward by some visual artists in the US who have launched legal action in relation to Stability AI and Midjourney, both of which are AI tools that are used to create images. Now, I'm not going to go through all of the cases, but I do want to list them here on the next couple of slides because there's quite a lot of cases in the US. So at the moment, there are 5 cases in the California courts. There are also 5 cases in the US courts. And they're all sort of cases that were commenced in 2023 or early 2024. There are 2 other US cases there, a UK case and a French competition authority decision that has been handed down as well. That decision is a little bit different from the other cases that I've got listed there because it really relates to competition law and Google's use of news stories as part of their platform. And there has been a decision that's been handed down by the French competition authority, and Google has agreed to make changes and has paid a fine. So that matter is a little bit different, but all of the other cases at the moment, we don't have any decisions yet. So it's going to be very interesting because it's sort of a flurry of AI copyright infringement cases, no decisions as yet, lots of different motions and applications being filed by different parties in each of those matters. And it's going to be very interesting to see what decisions are handed down. For us in Australia, the other thing to remember is that these are all overseas decisions, the majority of which are in the US. Their copyright laws are slightly different from ours in Australia. And as I mentioned earlier, they have that broad fair use exception that we don't have. So it's a bit of a watching brief at the moment in terms of how these cases will play out. But I did want to talk about 2 of them in particular, just because I think some of the policy issues that are raised in the cases and considerations of, what kind of world we want to live in when it comes to media and art. And really, that's one of the big things about these AI tools that we really kind of need to focus on. So one of the cases that I've focused on here is New York Times Company and OpenAI and Microsoft. So the Times filed a claim against OpenAI and Microsoft, claiming that both of those particular AI platforms had used millions of Times articles to train their platform like ChatGPT, etc., to provide answers to certain questions. The Times is interesting because it has a paywall. It's a media company that has continued and relies on subscribers. It also sees itself and holds itself up as a media organisation that believes in independent journalism and the importance of journalism. And so while we don't have a decision yet in relation to this case, and the latest was case management orders that were made in May 2024. So it's all kind of very recent. Some of the motions that are being filed an application that was filed by the Times, are really interesting because not only are they focusing on the infringement of copyright, and there were also competition issues raised in this matter as well. As you can see from the quote that I've got up here, the Times is really focusing on the importance of independent journalism and really asking whether we want a world where we only have answers to questions provided by something like ChatGPT, or do we want independent journalists who are able to, as they say, bear witness to conflict and disasters and provide accountability for the use of power and illuminate truths that would otherwise go unseen. Posing this question of the essential work that is undertaken by the media. In the same way, the other case that I just wanted to focus on quickly is a visual artists class action, which was started initially by 3 visual artists, Sarah Anderson, Kelly McKernan, and Carla Oritz. And they filed a claim against 3 different AI tools, Stability AI, Midjourney, and DeviantArt. That was because they were able to work out that their art had been scraped and used as part of the training process. And in some of the evidence that you can see that they've put forward as well, you can actually see quite clearly that their works can quite easily be reproduced and used through those particular platforms. There were some interesting issues that have come up with this one because the US has a copyright registration system that we don't have. You don't need to register copyright in Australia. And it has now become a class action with a number of other artists who've been joined as part of the proceedings. But they have posed this question again, which I think is also a really important sort of policy issue for us to think about as both lawyers and creators, is what do we want to protect? Do we want platforms that can create works in a particular style rather than, as this quote suggests, having to go to the artists and commission them or pay them to create the work? And that is a really interesting question because our copyright laws don't protect styles or ideas. It protects a work that is created. So that also raises a really interesting question as well. But really, you know, if we want to have a creative sector, if we want to have artists that are part of the communities that we live in and the world that we live in and support artists to keep creating, then these are really important questions that we need to ask. And so it will be really interesting to see the decision that comes out of this particular case. This case is also interesting because the artists were able to provide really clear examples of how their work has been used in the platforms without their permission. So, for example, Kelly McKernan here has got an image that comes up when you search her name, which is a slightly amended version of a work of hers. And so it's an AI generated image that's been made with Midjourney, but is clearly reproducing and communicating, because it's online, a substantial part of her original work. And here, one of the artists was also able to show, so this is Carla Oritz's work. Carla Oritz was also able to show how her work had been taken, scraped, being the top picture that's up there, top artwork, and then used on a whole lot of different platforms. So LAON, and some of you may already know this, stands for Large Scale Artificial Intelligence Open Network, and it's run by a German not-for-profit, but essentially it sort of is a data set that indexes in images that are on the internet. So it'll show you where an original image comes from, and then it will show you also where that image comes up on other URLs or other sites. So it can show the linked sort of images. And via this process, Carla Oritz was able to show how her work has been used in a whole lot of different platforms such as Midjourney. The matter's also interesting because it pulls together a lot of evidence that the artists have collected in relation to statements that have been made very publicly, sometimes on Twitter, by those who work for companies like Midjourney, where, you know, they're sort of clearly making it clear that copies are being made, but also that there is an issue with attribution and the difficulty for them with providing attribution if there are lots of different works that have been sort of melded together to create the final output image. So we will keep watching this space along with organisations like NAVA, and we'll await some of those decisions overseas. It will also be interesting to see whether there are any litigation matters that are commenced in Australia. We don't have any as yet, but if that happens, you know, it'll be interesting to see what the decision is there. There is a lot of regulatory things happening as well, both overseas in the EU, the UK and the US, but with a focus on Australia. There's been a number of Attorney Generals roundtables, a copyright enforcement review, and following the roundtables, there is now a copyright and AI reference group, which has been set up to consider what is happening in this space, the impact on creators, and both the tech companies and also creator representative organisations such as collecting societies, NAVA, Arts Law, Australian Society of Authors, Australian Writers Guild, and many others have been involved in those discussions. And again, talking about the impact on creators and what can we do in this space to ensure that infringements are not taking place and that artists are compensated if their works are being used. There has also been a recent Senate Select Committee on Adopting AI in Australia review, and people have made submissions as part of that process as well. So that really brings us to next steps and what we can do. But I also wanted to finish off with just highlighting the results of the survey that NAVA and Arts Law ran last year. And this is just a really small snapshot, but the survey was great because it did give us, both NAVA and Arts Law, some more feedback from creators about how they're using AI and the impact of AI. And we were able to use that information, plus the information that we get from regular discussions with creators, to make submissions to government. What we did find was that a lot of creators, there are some creators who are using AI as part of the creative process. As part of the survey, 86% of the respondents were visual artists. We were really sort of focused on that, but we did have, you know, writers and musicians who also provided responses. But there was a really big, overwhelming concern about the impact of AI on creators, a threat to their creative professions. People talked about work that they had lost or the lack of work following the huge introduction of AI tools. And the negative impact on the amount of money that they can make, and a real concern that generative AI would be used to replace human creators. So I think it's really important for us to balance that out with the fact that some creators are using it as well. So before we go to some questions, which Emma's going to facilitate, I thought it would also be great to talk about next steps, because I know we're looking at cases that are happening overseas, and you know, there's lots of things happening in the regulatory and policy space, but there are things that we can all be doing. I think one of the important ones is sort of supporting and getting involved in organisations and peak bodies like NAVA, Arts Law, or if you're a writer, the Australian Society of Authors. Because those organisations, we can all work together to advocate and support creators during this process. If you want to advocate, then, you know, pushing for guidelines or legislation or the introduction of AI ethics principles by government is an important step that we're hoping government will take. And I think also focusing on supporting and allowing for the growth of Australian creators and organisations and communities is really important. And that was one of the things that I wanted to draw out from those US cases, is just thinking about what society we want to create for the future. And do we want journalism and filmmakers and writers and artists to exist in the world that we live in? The other little sort of technical or other tips and tools that people can undertake are making sure that if you're using like an online platform or working with a publisher, that you read the terms and conditions or the agreement that you're signing, because we are seeing a number of terms and conditions and agreements where there will be a clause that allows the third party to essentially license the creator's work for the purpose of licensing on to someone else for an AI platform. Even in the publishing space, that's something that's come up for creators. If you're not sure, seek legal advice. If you think that your work may have been infringed, also please seek legal advice. Arts law can assist, and where we can't, we can refer you on to someone else who can. There is also the option now to opt out or request removal of your work. It isn't possible with all of the sites like Midjourney and DeviantArt, etc., but some of them do have an opt-out process now. If you are able to use things like haveibeentrained.com to work out where your work has been used, some of the sites do have an opt-out process. I understand that some of the opt-out processes are quite difficult and technical, a bit like getting yourself removed from Facebook. If you're on there and you no longer want to be there, I think there is a bit of a process that you have to undertake. There are also blocking tools that some creators are using as well, because for many creators, the idea of not having a website where they have their artwork up, or not using social media, whether it's Instagram or other sites, is a really difficult prospect, because for many creators, that's how they engage with people who want to buy their work or commission them to create works. So some of the blocking tools that people have had some success with are Glaze and Nightshade. I haven't used them myself, so I don't know exactly how they work, but it's definitely something to look into as well. And if you're wanting to work out whether your work has been used, as I said, haveibeentrained.com is useful, and reverse Google image searches can also be useful as well. One of my colleagues at Arts Law had a look at haveibeentrained.com, and we found that there are definitely some Arts Law photographs and other images that were in there as well. So it's, if you have a website and you've got your work up, then it's a good chance that you might find something when you have a look on haveibeentrained.com. But I'm going to hand over now to Emma. I know she's got some questions that she'd like to pose, and I think you can also put questions in the chat now. Is that right, Emma?
Yes, you can. Thanks so much, Catherine. That was really, another comprehensive session, and some really interesting case studies that you've raised there as well. And I love the point about the almost philosophical thinking around like what kind of world do we want to live in, and like what's the role of the artist, and the importance of still advocating for human artists amidst all of this. So yes, we're going to move into some questions for Catherine now. I see that a few have come through. If you've got burning questions, please put them in the Q&A feature. But I guess I'll kick us off with a few questions. So there are some organizations like the ones in the US that you kind of mentioned that kind of offer a platform for people to access images that have been created by individuals, which have been scraped from the internet. And these individuals haven't had the opportunity to either opt in or opt out of this data scraping process. So, and I know you mentioned that this is all still in dispute, but in your opinion, do you still think that this is enough to constitute a copyright violation? Because it is essentially reproducing a digital work.
Yeah, I think there's probably, like I would say, there's a good chance that there's a substantial part that's been reproduced and communicated during the input training process, and then possibly stored, and then possibly comes out the other end during the output process. It would depend on each particular work that you're looking at. And it was interesting during the Attorney General's Roundtable process last year, which NAVA was also involved in. I think all of the organisations that were there, like Arts Law and NAVA and Australian Society of Authors, the collecting societies, those who represent creators, were very unified and clear that our copyright laws, particularly in Australia, are very clear. Like if you create a work, it's an artistic work, for example, you're the copyright owner, you have exclusive rights. There are fair dealing exceptions, but none of those would apply in this particular situation. It's very clear that it seems like there's some copyright infringement going on there, but because there's no transparency about what images have been used, although we seem to be able to see a lot of them now. Yeah, the lack of transparency makes it really difficult. And so many organisations and some of the music collecting societies have been advocating quite strongly for a licensing system that recognises, for example, in the music space, that some of these tools have been scraping and using musical works, and that there should be some kind of licensing system that's set up so that the artists whose works have been scraped and reproduced and communicated get some compensation for that. But I think the other thing that you're sort of raising as well is, what about the person who uses that tool, that AI tool, to create something? Are they potentially infringing as well? And it might be that they are, if there's an underlying work there and there's a substantial part that's been copied, so communicated or reproduced. And so, yes, perhaps some of those individuals would also be infringers as well.
And I guess leading off of that, also thinking about what the obligations are of artists who use AI generative tools in their practice. So is there a responsibility, A, to disclose that they're using these types of technologies, and B, kind of going off the discussion around moral rights, is there a responsibility there for them to attribute or acknowledge the original works that were scraped and that have technically contributed to the AI generated work?
I mean, I think for some creators who are using the AI tools, it's going to be very difficult for them to know themselves. So yeah, that is hard. I think that there's a lot of work in that. It's almost the consumer law space about being upfront and honest about the tools that you've used to create your work. And I think for many artists, that's also an ethical issue, being upfront about that. And there may also be prizes and competitions that include terms and conditions that require that the artist declares whether they've used AI to create. But then there are going to be other terms and conditions for other competitions where they're going to be open to people contributing works that have been created by AI.
Yeah, I mean, there have already been some art prizes and competitions that where this question has come up of whether or not to allow entry of AI generated works, and some have, with on the conditions of that the artist discloses what and how the AI tools have been used, or that the work can't be wholly AI generated. So yeah, I guess I wanted to get your sense of do you think this should be allowed, and are those caveats and conditions that I mentioned, is that enough to ensure that competitions are equitable and that it still constitutes as ethical use?
Yeah, I mean, probably the ethical questions are a little bit separate from the legal questions. And if there was an artist that was concerned, I mean, if they're using an AI tool and they're concerned that their work that they create may be infringing the copyright of other creators, then I would really recommend that they get legal advice, because every situation is going to be different and every work will be different. But I think it is the question that creators who are using AI tools should ask themselves, because yeah, both for the ethical and the legal reasons. Yeah.
Totally. All right, I'll see if I can throw some of the questions from the audience. Okay, so one that came through earlier, just so everyone's clear. So AI cannot own any artwork created. Is that what the?
So the way that our Copyright Act works in Australia, and it you know, different jurisdictions will have different rules about this, is that for an artistic work, there needs to be a creator, and generally it needs to be a human effort. It needs to be a human person who creates the work. Now, the copyright can be owned by a company or an individual. Under our legal system, a company is almost we talk about them being a legal person. So yeah, it can be owned by a company. The question of whether an AI tool can create something and it be owned by the tool is sort of another issue. But yeah, it is possible that the AI company may own the copyright in the works that are created. But generally, the way that it works under our Act is, yeah, you need to have that sort of human creator there. So that's why I use that example of, you know, the German photographer Boris Engelmann, because although he was using an AI tool, he was almost, as I said, like using it like it was a paintbrush. And there wasn't probably enough of a human effort there and input for him to be considered the copyright owner of the work that was created. Yeah. But again, probably a bit of a case-by-case situation.
Yeah, it's hard when nothing's really resolved at the moment.
Yeah.
We've got a question from Gregory. Does this also mean that potentially where the AI tools or services are made / registered, limit the jurisdiction? So that is Australian laws that differ from international laws, limit the jurisdiction that can be applied in an infringement case?
I think I know, sorry, I think I know what he's asking there, but so look, there are slight differences in the laws in different countries. And I think the person who posed the question there was asking about the US registration system. It is a little bit complex and a little bit different there. You need to register the copyright before you can commence legal proceedings for infringement, but you still get copyright ownership when you create a work. The question of where you would commence proceedings for infringement is also a little bit technical, but given that we're talking about a platform that's available on the internet and it's available everywhere, if you were an Australian artist and your copyright was infringed, you know, on Stability AI or another platform, then you would probably commence proceedings here in Australia. But yeah, it's a little bit of a technical question about, you know, different jurisdictions. But generally, you know, we have copyright in Australia, we have our Copyright Act. Other jurisdictions also have copyright laws, and there is an international treaty, the Berne Convention, between different countries that sort of give us a little bit of like a reciprocal protection. So yeah, I think that answers the question.
Yeah, and I've got a related question from anonymous attendee. So can a US company scrape work from Australian artists hosted in Australia and still claim fair use?
Okay, so it would depend. That's also a bit of a question about where the proceedings were commenced. So, I mean, the infringement is of an Australian artist's work, if the proceedings were commenced in Australia, then the artist would say there's no fair dealing exception. But if you commence proceedings in the US, then obviously there's fair use over there. So again, a little bit of a jurisdictional question. But I guess some of the discussion that's been happening, you know, in the academic space, in the legal space, is that, you know, if there was a copyright infringement case that was commenced in Australia, it would potentially have a different outcome here than it may have in the US, because there is no fair use exception that, you know, the infringer would be able to rely on. But as yet, we don't know, because we haven't had a decision in those US cases. We don't know whether fair use is actually going to be something that people will successfully be able to rely on there either. So it's a kind of a watch and see at this point.
Yeah, it'll be interesting to see what comes out of those US cases. So pivoting a little bit now, John's asked, what responsibilities do art galleries and curators have in regards to the use of AI in the art that they show in their galleries? So is there a responsibility to disclose whether AI has been used in the artworks? Is there a responsibility to adhere to copyright? What are your thoughts?
So, I mean, again, a lot of that is a bit of a decision that's in an ethical space. I mean, there are consumer laws that would come into play, and we haven't talked about Australian consumer law today. But obviously for anyone that was selling an artwork and they were selling it and saying that it was painted by an artist, but it was actually created on an AI platform, then that could be potentially misleading and deceptive conduct in the course of trade, you know, the selling artwork. So that's probably where the legal issue comes into play more than anything. And then obviously, like, there's an ethical issue there in terms of, you know, what you're telling consumers when you're selling an artwork as to how it was created. In terms of copyright, if the gallery is not engaged in any reproduction or communication, then the copyright issue isn't really going to come into play as much for them. Yeah.
Thanks, Catherine. Okay, we've got one from Anonymous. What about when scraping was done off art hosting websites in breach of the terms of services of those hosting websites?
Yeah, okay, so that's an interesting one. And we also haven't really talked about that today. But yeah, lots of websites will have terms and conditions attached to the website, you know, whether it's a gallery or another website that hosts images on the website. And sometimes those terms and conditions, so website terms and conditions, will say that people cannot reproduce the images on the website without first seeking a license from the website owner, whoever that might be. So yes, it could be a breach of those terms and conditions. So that's another avenue for people if they have a website and they have artworks on it. Not only may there be a copyright infringement if their works have been scraped from that website, but there may also be terms and conditions that have been breached as well. But yeah, so that's an interesting question. We haven't really delved into that aspect of it today.
Thanks, Catherine. We'll ask a few more. Okay, I see an interesting one. What about, this is from Anonymous. What about when an artwork is being acquired into a collection where non-exclusive copyright for online access is obtained?
Oh, okay. So the artwork is being acquired into a collection, like an art gallery collection, and the gallery also gets a non-exclusive license to reproduce the work.
Yeah, where non-exclusive copyright for online access is obtained.
Okay, and is the question whether is the question about whether that artwork is an AI generated artwork?
I assume that's what this person means.
Yeah, I'm not sure. Sorry, I'm not sure what the question is. Can that person
Yeah,
ask it again?
yeah, clarify that question. In the meantime, I'll go to another one. Okay, this is one from Ben Loveridge. How likely is it that media companies will go after individuals who use AI tools that have been trained on copyrighted works, in the same way when MP3 file sharing became a thing?
All right, interesting. Great question, Ben. I mean, I don't know. I can't say how likely it is, but I mean, given particularly in the US, we've seen the New York Times commencing proceedings against the, OpenAI, for example. It may be that, they will also sort of consider taking proceedings against someone who is using, say, ChatGPT to write articles for their own website. And, if those ChatGPT articles reproduce substantial parts of, the media organization's articles, so the New York Times, for example, yeah, definitely. I mean, there is a real potential there of that happening. I mean, I know that the Australian Writers Guild have used a really interesting example of copyright infringement being the Strictly Ballroom script, and that they sort of found examples of, putting a question in, write a second movie for Strictly Ballroom and then spit out a script. And in the resulting script, there were sort of large chunks of the original script that were reproduced. And so, that's a potential copyright infringement there. So if someone was to use that tool or another tool like that to create a script, and the resulting work involves a reproduction or a communication of the original script, then yeah, someone who goes off and then makes the film and uses it may potentially be looking at, a complaint from the original copyright owner.
Thanks, Catherine. So we've got the clarification of the previous question.
Oh, great. Sorry, I didn't get it.
No, that's okay. Yeah, thanks for clarifying this one. So in terms of gallery responsibility of ensuring acquired artworks are not breaching copyright of other artists in the making, so for example, using AI, the artists will need to sign the non-exclusive agreement to allow collections to display work online for education purposes. So the question is, would it be worth looking at existing copyright agreement to ensure this is addressed?
Sorry, so the responsibility for the gallery to ensure that the work that they're acquiring doesn't include the reproduction of another artist's work, like through an AI tool.
Yeah, I think that's what
I mean, I think it's probably something for galleries to be really cognizant of and to think about. I mean, for the artist as well, if they know that they've used an AI tool to create the work, and then they're entering into an agreement with a gallery where they're warranting, so they're promising that it's an original work and that it doesn't infringe the rights of a third party, I think that artist should really get some legal advice about whether they're actually able to make that warranty or that promise that it is an original work. So there's kind of a couple of different things at play there. I think for galleries will be thinking quite clearly about it, and probably have their own considerations that they'll take into account when they're acquiring works, and ensuring from an ethical standpoint as well, if AI is involved. But yeah, also the artist, if they're signing an agreement, whether it's got a non-exclusive license in it or not, they would need to be careful as well and probably get some legal advice about the agreement that they're signing if they know that they've used an AI tool and they've got concerns.
Thanks so much, Catherine. I think we might actually, leave it there for questions. I saw a few around like music and education stuff. It's just a little bit out of NAVA's remit, but still feel free to include it in the survey that we'll send around. Because it is a sector effort.
Definitely.
Yeah.
And I mean, I should also say that if people have got questions that we haven't addressed today, specifically if it relates to their practice, or they're concerned that someone else has been, infringing their work, to please contact Arts Law, and we can give you some very specific and confidential legal advice as well. On our website, there's a query form where you can put your query in and receive advice, and we can give you a call and have a chat over the phone about it as well. And if there were questions that came through today that I didn't answer properly because I didn't have all the details, then please also feel free to contact me at Arts Law. I'm very happy to chat through things as well.
Yeah, absolutely. It can be a bit hard to answer these questions on the spot. So you did very well, Catherine. And
thank you very much for having me.
Thank you for coming on board. And thank you to everyone who asked a question. Like Catherine said, if we didn't get to it, you can pop it in the survey that we've put into the chat. And we'll figure out ways to address all your questions post the event.
Thank you, Emma. And thank you to our wonderful Auslan interpreters as well.
Yeah, thank you so much. Our final session for NAVA Talks AI is happening next week on the 29th of May on the Wednesday with Caleb Graves, who is a multidisciplinary and conceptual media artist, and he'll be discussing his approach to incorporating AI in creative expression, exploring its potential to inform artistic expression while addressing questions of authorship, authenticity, and ethical implications. So it'd be interesting to hear from an artist's perspective. Just to wrap up, want to also acknowledge and thank our funding bodies. Without their support, NAVA would not be able to undertake this work. So thank you to Create New South Wales, Arts Queensland, and Creative Australia. If you want to get in touch with NAVA, you can reach us on nava@visualarts.net.au. And if you're interested in our membership, you can visit our website, nava.net.au. That's all. Thank you so much, everyone, for joining us, and goodbye from NAVA and Arts Law.